Good afternoon, everybody. Very warm welcome to this Five Stone Buildings webinar on conflicts of interest and professional deputies. Just so you're aware, this webinar is being recorded. My name is David Rees QC, and with me today is my colleague Ruth Hughes. We're both recommended as counsel for our work in the Court of Protection in Chambers and Partners directories. And Ruth is a member of the Attorney General's B panel as well. Today we're going to be speaking about a case in which we were both involved, a case called Ray ACC and others, neutral citation of which is 2020 EW COP 9. This is a decision of the senior judge of the Court of Protection, Judge Hilda, and it was handed down on the 27th of February. So just over 3 months ago, but what seems like a world away at a time when we weren't locked down and we were able to discuss things face to face rather than on the internet. It's a very interesting case and one that has caused quite a lot of controversy and I think concern as well amongst solicitors who practice in this area. And Ruth and myself today are going to be exploring the judgment and some of the implications for solicitors and deputies who practice in this area. The case itself, although it's called Ray ACC, was in fact 3 cases that they were listed to be heard together, although the cases weren't joined. And they've been listed by the senior judge to be heard together as all 3 cases explored potential conflicts of interest that can arise between solicitors who act as deputies or indeed trust companies owned by solicitors who act as deputies, and the position of P, the person who lacks capacity, in circumstances where the deputy wishes to instruct their own law firm to provide services in connection with the deputy. As I've mentioned, both Ruth and myself were involved in this case. I was instructed by Erwin Mitchell to act for the applicants in all 3 cases, and Ruth was instructed by the official solicitor, who was acting as litigation friend for each of the 3 individual people who lack capacity to whom the case is related. There was a third counsel involved, Joanne Clement, who acted for the public guardian. The public guardian was joined really as an interested party on the basis that his statutory obligations to supervise deputies was something that gave him a very genuine interest in the outcome of these proceedings. Now this afternoon, rather than subject you to 2 monologues, myself and Ruth talking, we are going to go for the Socratic method of questions and answers. I will ask Ruth some questions, she will ask me some, and we hope that our respective answers will provide some elucidation on the case. There will be an opportunity also for you to ask some questions at the end as well. There is a function, I hope, working on your web browser or Zoom link, which will enable you to put questions and answers, put questions in the question and answers box, and we will do our best to answer some of those at the end of the talk. If you don't want to be identified when you put your question forward, there is an anonymous box, and you're welcome to do that and use that box if you wish to. So the first question that is going to be posed to me is going to be posed by Ruth. Ruth.
Yes, David. So you mentioned that there were 3 joint cases listed together by the senior judge. Can you tell me a little bit more about the facts of those cases? What was really going on here?
So there were 3 cases, and each involved a different person who lacked capacity, and there were a different factual background in each. And the 3 cases, 2 of them were a bit similar, the third was rather different. So to run through them briefly, the first case, which is set out by the judge in her judgment, is the case of ACC. And she had been involved in a road traffic accident when she was about 4 years old. And by the time of the application before the court, she was 20. Erwin Mitchell Trust Corporation had been appointed as her property and affairs deputy, with a standard form deputyship order, the sort of order that I'm sure all our audience are familiar with. And that order did not give the deputy any express authority to litigate on her behalf. The local authority decided that it wished to end the support that it had been providing to ACC under an education, health and care plan. And the deputy sought advice from Irwin Mitchell's public law team as to what they could do about that situation. And they applied to the court for an order to enable it to take proceedings to challenge that decision. However, time passed, and not least because of normal delays in the Court of Protection, but also because the court decided it wished to list all these cases as test cases, the deputy had to deal with the appeal against the local authority's decision without the court having made any decision. So it took advice from the public law team, and indeed an appeal was issued, and in fact that was settled, so that by the time the case came before the Court of Protection, it was limited to an application for retrospective approval of some fairly limited costs that had been incurred on P's behalf. The second case, one of JDJ, was relatively similar. In that case, an individual solicitor rather than a trust corporation was the deputy. JDJ was 17 years old, and again a dispute had arisen with the local authority over an education, health and care plan. Again, there was an application to the Court of Protection that was issued in order to obtain authority to challenge that decision, but again in the meantime the challenge had to proceed, and as a result the deputy, who was a solicitor at Irwin Mitchell, instructed that firm, but in fact the terms of engagement were signed by JDJ's parents, because under the Special Educational Needs Tribunal regulations they were going to be the ones who were actually challenging the decision. And the application was for authority for those costs which were technically being incurred by JDJ's parents to be met by the deputy out of JDJ's funds. Again, because of delays in the meantime, the appeal had to be issued. Counsel's advice was taken that the appeal had good prospects of success. And in fact, though, by the time the Court of Protection hearing came along, the appeal had been heard. And JDJ in fact only achieved very limited success on the appeal, but it had achieved something for him. And again, by the time it came to the Court of Protection hearing, it was really an application for retrospective approval of the costs that had been incurred. The third case, HPP, was a bit different. HPP was about 50. Irwin Mitchell Trust Corporation again had been appointed as his deputy, and this related to personal injury proceedings that had been brought on HPP's behalf in the Queen's Bench Division of the High Court. Initially, HPP's partner had been the litigation friend, but they had been replaced by a solicitor at Irwin Mitchell later on as the proceedings in the QB progressed. By the time this application came before the court, what was being asked for on behalf of the solicitor at Irwin Mitchell, who was acting as the litigation friend, was firstly authority that she could charge for acting as litigation friend. Secondly, authority for her to instruct Irwin Mitchell on HPP's behalf within the claim. And thirdly, authority that she could be indemnified from HPP's funds for any costs liability that she incurred, both in respect of adverse costs orders to the defendant for the QB proceedings, and indeed for Irwin Mitchell's own costs within those proceedings, to the extent that they were not being directly paid by the defendant. So those are the facts. Now, Ruth, the senior judge's decision, in fact, covered a range of issues. What are the main issues which arose from her decision?
So I think that there are three main issues which are, I think, the most important ones. One is to do with the issue of charging for acting as litigation friend. 2 is the need to obtain authority to litigate at the letter of response stage. And 3 is the need to tender when obtaining legal services on behalf of P. So just briefly on charging for acting as litigation friend, one of the applications involved a initial request, which was in fact later withdrawn by the partner Irwin Mitchell, to charge for acting as P's litigation friend. And although the senior judge decided that she didn't have to deal with the issue of whether it is legally possible to charge for acting as litigation friend, and it might well be legally possible to get authorization in the right circumstances, those circumstances are hardly ever going to exist, because the official solicitor said that in all the cases where her usual criteria apply, for example, where there's money to pay the costs, that she will act as litigation friend for P in proceedings. So it's going to be very difficult to persuade the court that it's in P's best interest to charge for that service that the official solicitor is willing to provide for free. So that's charging for acting as litigation friend. On the need for authority, the senior judge found that there was authority within a general property and affairs deputyship to do the very initial work of looking into litigating on P's behalf, either as a claimant or a defendant. But by the time litigation gets to the letter of response stage, if a deputy wants to litigate on behalf of P, they're going to need to apply for court specifically for authority to litigate in P's best interests before they continue to act. And on tendering, I'm just going to say a small amount about tendering now, because I'm going to return to tendering because I think it's a really important issue. It's clear that the court will not simply accept that a deputy should be instructing his or her own law firm to act for the deputy in litigation for P, and a best interest decision together with tendering of, say, 3 law firms is going to be needed so that best value can be obtained for P in obtaining those litigation services. But David, the judgment deals with the scope of the deputy's general authority on a more wider basis than just that. What acts are inside and outside the general authority of a deputy under a normal property and affairs deputyship order?
Well, Ruth, the standard deputyship order, which is made in virtually all property and affairs cases by the Court of Protection, contains, normally at paragraph 2A, the following wording: the court confers general authority on the deputy to take possession and control of the property and affairs of P, and to exercise the same powers of management and investment as P has as beneficial owner, subject to the terms and conditions set out in this order. And what the judge did in her judgment was to shed a little bit of light on what those difficult words, general authority, actually means. What is and what isn't within the scope of the terms of the deputyship order. First thing to note, and this is something I think, Ruth, you're going to talk about a little later, is that litigation is outside the scope of the general deputyship order. And a deputyship order does not, under any circumstances, give a deputy authority to bring proceedings anywhere as litigation friend for P. There is a more limited carve-out which will enable a deputy to make an application to the Court of Protection in certain circumstances. But of course it should be noted that where a deputy applies to the Court of Protection, they are acting in their own right as a deputy and not as litigation friend for P. In Court of Protection proceedings, P will be separately represented from the deputy, generally through the official solicitor, acting as their litigation friend. Another thing that the judge held was outside the scope of that paragraph, the general authority, is conveyancing. But that can be encompassed within an order. Normally, a power to buy and sell property is expressly set out in the terms of a deputyship order. And where the court has conferred such a power on a deputy, implicit within that, the judge said, was the power, was an entitlement to carry out the conveyancing acts and instruct a solicitor to do that conveyancing process. So the general authority doesn't include the ability to instruct a solicitor to do the conveyancing, but if you've got a specific power within the order to enable you to buy or sell property, then that will enable you to instruct a solicitor, including the deputy's own firm, to carry out that conveyancing. Similarly, the general authority doesn't cover with it power to get authority in relation to any letting of P's property. That again needs to be encompassed by a specific direction with the order, enabling the deputy to let property on behalf of P. And a similar point applies in relation to acts relating to P's business. So if P has a business, there may be issues relating to the debts of that business or to employment contracts relating to that business. And again, general authority wouldn't enable the deputy to deal with those matters, but a specific order within the deputyship order that the deputy could carry on P's business would enable the deputy then to deal with acts that are essentially ancillary to the running of the business. What the judge said in her judgment, key passage, is that general authority to do an act on P's behalf, and I quote, encompasses such ordinary legal tasks short of taking proceedings as are ancillary or part of giving effect to that authority. So, for example, what is encompassed within a general authority is a power to take advice on putting together a tax return for P. So that's something that a solicitor can delegate to their tax partner and ask them for input in relation to that matter. Likewise, if there is a tenancy being taken out for P, so P is going to rent a property, the deputy can take advice in relation to that tenancy. And if the deputy is involved in an employment contract directly as part of its property and affairs jurisdiction, for example, the direct employment of carers for P, then again the deputy can take advice in relation to those employment contracts without getting permission from the court. Now, it should be noted that in relation to these non-contentious matters, no financial limit was set by the court on the amount that could be spent, but the court made very clear that it would expect any non-contentious costs to either be claimed under the fixed costs regime under Practice Direction 19B, or to be the subject of a detailed assessment by the Supreme Court Costs Office as part of the deputy's annual accounting process. So it was clearly never intended by the judge that significant non-contentious costs could be incurred in this way. So far as contentious matters are concerned, it is possible within the terms of one's general authority to take advice up to, but not including, the exchange, the start of proceedings, essentially up to and including a letter of response, but not issuing proceedings, if the matter relates to the person's property and affairs. If it relates to a welfare matter, such as, for example, a challenge to an education, health and care plan, that is not within the scope of the deputy's general authority, and the most the deputy should be able to do is to go to the Court of Protection and say, this issue has arisen, please can I have some directions. There is an exception to all of this, as I've already mentioned, which is if what is proposed is litigation that is going to be taking place within the Court of Protection, that is something the deputy is able to bring without permission. And on that point, Ruth, one of the issues that has, I think, caused some confusion for people reading the judgment are the judge's comments on when an application needs to be made to the Court of Protection for permission to bring proceedings within the court itself. Can you expand a bit more on the rules that apply here And in particular, would a deputy need permission before making a statutory will application, for example?
I know sometimes Chancery barristers get criticised for giving unclear advice, but the advice here is very clear. You do not need authority from the Court of Protection to bring a statutory will claim. If you think it's in P's best interest to bring a statutory will claim, you can just issue it. Having said that, I know that there have been some suggestions that you might, if you're instructing your own law firm, that might be open to some kind of challenge. Personally, I don't think that's the case, because the firm is going to be acting for you in your capacity as deputy rather than acting for P, because the official solicitor is going to be acting for P. But the clear point is that you do not need permission to bring a statutory will application as P's deputy. The same applies to all property and affairs applications. You do not need permission to bring a property and affairs application as P's deputy. You will need to ask for directions if you want to be involved in bringing a welfare application. It's your duty as a property and affairs attorney to bring a welfare matter to the court's attention, but you shouldn't dive into getting a large amount of expensive advice and bringing proceedings off the bat without the court's support. So yes, ask the court for directions about welfare matters, but property and affairs matters, you can, if you think it's in P's best interest, just issue the application. No need to worry about that. But David, what's the position with civil proceedings? It's right, isn't it, that you don't actually need authority to litigate to act as P's litigation friend in civil proceedings. How do you become a litigation friend for P, and what are the advantages of having authority anyway?
Litigation friends within civil proceedings are governed by Part 21 of the Civil Procedure Rules, and they provide a mechanism whereby a person can become a litigation friend within civil proceedings without the need for any kind of court order. And there is a sort of list of priorities which can be found in parts 21.4 and 21.5 of the Civil Procedure Rules. First person who has priority is somebody who's actually been appointed by the civil court, the Queen's Bench or the Chancery Division or the County Court, to act as litigation friend. Subject to that, you can act without a court order. Firstly, if you are a deputy who has been appointed by the Court of Protection and has specific authority to bring proceedings as litigation friend on P's behalf. That second point there is very important, because as I've already indicated, a general authority in a deputyship order does not include authority to bring such proceedings. So most deputies are not specifically authorised by the Court of Protection to bring civil proceedings. And as such, they can't rely on that section. So unless you've got a court order that expressly says you can bring these proceedings on P's behalf, you can't rely on that bit of the CPR. What you can, however, do is put in a certificate of suitability to say that you can fairly and competently conduct the proceedings, that you have no interest adverse to P, and that you will give the necessary indemnity on costs, which is that you will meet any costs order that is ordered against P, subject to any right you may have to be reimbursed or indemnified for those costs. And if you can do those things, you simply have to file your certificate of suitability at the relevant time, which is at the start of proceedings if you're going to be litigation friend for a claimant, or the first time the step is taken for a defendant, if you're going to be litigation friend for a defendant. If you fall outside those circumstances, you can't act as litigation friend without a court order, but you can get an order within the relevant civil proceedings under Part 21.6, appointing you as litigation friend. Now, I've mentioned the costs indemnity. This is a situation which is quite complicated, and is being made more complicated by a decision of Mr. Justice Morgan in a case called Barker and Confiance, which was decided last year, and as I understand at the moment is the subject of an outstanding appeal to the Court of Appeal. At common law, there was a general right that somebody who acted as what was then called a next friend or guardian ad litem should, as a rule, be entitled to recover any costs that they have incurred in acting in that capacity from the person on whose behalf they're acting, that's to say P. But that is now very much subject to rules in Part 21 of the Civil Procedure Rules, which make it clear that one can essentially only recover costs where they are being authorised by a court. And indeed to a more general principle, which was that the common law right to an indemnity was always subject to those costs having been properly incurred and therefore subject to some form of approval by the court. Barker and Confiance was a case, in fact, where the High Court said that it could make cost orders directly against a litigation friend, so that if a litigation friend took a step in the proceedings which was worthy of a cost sanction, it could make the costs order directly against the litigation friend rather than against P. So at the moment there is some uncertainty as to the extent to which a litigation friend would be automatically entitled to recoup any costs that they incur, either by way of a hostile costs or adverse costs order made against them, or indeed any costs that they incur as a result of instructing solicitors out of funds belonging to P. And I think it has to be assumed that they could only recover those if they are authorised to do so, either by the court that sees to the civil proceedings or by the Court of Protection. And this brings us on to really, I think, a very important point in the Court of Protection, that somebody, a deputy who's planning to act as a litigation friend, may well want to go to the Court of Protection in advance and get authority to bring those proceedings and to be indemnified out of P's funds for doing so, because otherwise there is a risk that they may be out of pocket. And really the sort of proceedings I have in mind is an application to the Court of Protection, a bit like a Beddoe application in trusts proceedings, where you go to the court and say, I want to bring these proceedings on P's behalf, please may I have authority to do so, and please may I have authority to indemnify myself for my reasonable costs, both in terms of an adverse costs order and the costs I incur in instructing lawyers on P's behalf. So Ruth, turning back to the decision in ACC, what do you think are the practical implications for solicitors who act as deputies?
There are quite a number of practical implications for the decision because it's such a wide-ranging one on the general authority and authorisation to litigate. I think one thing that's going to be particularly important is where you are acting as P's litigation friend. You're going to have to be very careful with your time recording because it's very clear that you shouldn't be charging for acting as litigation friend without authority, and that may be difficult to always draw the line between what you're doing qua deputy and what you're doing as litigation friend, and so it's important to keep those records clear. It's also going to be important, I'm sure everybody watching this webinar takes letters of claim and letters of response seriously, but not all of the letters of claim and letters of response I have seen are always as full as they might be. It's going to be important for you to set out your case in detail in the letter of claim and the letter of response so that you're in the best position you can do at that point to get counsel's advice and put in place a sort of cost-benefit analysis, having obtained counsel's advice, so you can get that kind of Court of Protection Beddoe application that David was talking about. Now, it's sometimes there's going to be cases where it's not just a pound, shilling and pence answer to what's going to be for P's benefits. So in some of the health and education care plan cases we were talking about, there were benefits to P that weren't just in monetary terms, and of course you can take those into account in undertaking the cost benefit analysis, but you're going to want to be in a position to explain that to the court in a witness statement when you make your application for authority to litigate. So I think that taking the letter of claim, the letter of response seriously, and working out what all the benefits to P and all the costs of the litigation are going to be as best you can at that early stage is going to be practically very important. I said earlier that I was going to talk a little bit more about tendering, and I think tendering is going to be one of the main practical differences we're going to see in how people are acting as deputy when obtaining legal services for P following the decision. So you're going to want to be making a best interest decision about who to instruct after taking a tendering process of at least 3 law firms, one of which can be your own, you're going to want to document that best interest decision very carefully. Now, again, it's not necessarily a pounds, shilling and pence answer. Of course, you're going to want to have identified 2 other law firms who are in a reasonably good position to act for P, but cost isn't the only thing that you should take into account. The specialism and service available to P is also going to be relevant. So you're looking for best value rather than necessarily the cheapest cost. But you are, if you're going to want to instruct your own firm after taking that tendering into account, want to have a detailed and careful attendance note of that decision so that you can justify that decision to the court and to the OPG if you need to. So also, if you are getting appointed as deputy and you know that it's likely that you're going to want to obtain legal services on P's behalf, you can get authority at that stage, and that's suggested by the senior judge in her decision in ACC. So there are 2 particular examples that I have in mind where I have arranged for an independent professional deputy to act, and I definitely knew they were going to be providing needing legal services from their firm. So one example was when I acted for the official solicitor in a statutory will claim which is known as Reed Jones, and Mr. Jones had a rather large Jersey trust fund that he had set up, which unfortunately no tax had been paid on whatsoever at all. And we knew that the plan was to use the Liechtenstein facility to regularise the position with HMRC, and I knew that we needed a deputy who was going to replace the current deputy because there had been an almighty falling out around the statutory will. We wanted a deputy who had a firm who had a experience of using the Liechtenstein facility. So then now if I was doing that, I would make sure that that deputy was authorised to get quite extensive tax advice from their own firm in relation to that. And also it's very common for me to act for people who have been appointed as interim deputies or final deputies where it's clear that someone who has been acting previously has been or is suspected of financially abusing P. And I think where there's that financial abuse, it's very likely that you're going to want to bring proceedings, and possibly very quickly. So in those circumstances, I would seek to get automatic authorization to use their own firm. I think particularly where there's financial abuse, you might need to make an application for an injunction, which again I'm going to talk about a little bit more later. And if you think that there's any risk that you're going to want those injunctions quickly, I would try and get authority before you begin to act. Also, I think that if you want to act on a CFA, you will definitely want to bring the terms of the CFA to the attention of the court, because there is a real close difficulty with the conflict of interest there. There was a CFA in one of the cases in front of Senior Judge Hilda, and it was very clear from what had happened in that case that the risk of conflict of interest there is quite difficult for the firm to guard against. So the Court of Protection is going to want to see that, although it is fair to say that also the uplift will be, the reasonableness of the uplift will be considered by the Supreme Court Costs Office in deciding what costs are reasonable as well. But I would want my CFA approved by the Court of Protection too. Do you have anything to add to that, David? Is this decision going to affect deputies who work for like full service law firms more than others? Are they just going to be able to pick up the phone and ask their colleagues for some help if they have property or tax problems? That's normally what happens.
Well, so far as tax problems are concerned, Ruth, I don't think it's going to make any difference. The senior judge made clear that taking some tax advice certainly filling in tax returns and the like, is something that is encompassed within the scope of the general authority. So a deputy in those circumstances is still perfectly entitled to take some advice proportionately from members of their own firm. I think perhaps two general lessons from this. Firstly, it has emphasised the need for a deputy at each stage to consider whether a particular act that they are proposing to take within the deputyship is actually encompassed by their general authority or not. Is what they are doing ancillary to the authority that they already have within the Property and Affairs Deputyship Order, or is it something that falls outside that, where they may need to get authority from the court? Secondly, whilst it's put flesh on the bones of what solicitors are now required to do to demonstrate they are acting in P's best interests and addressing the potential conflicts of interest that exist, to some extent, what the court has done is simply make explicit what perhaps ought to have been implicit in the first place. So that, for example, if one is proposing to instruct one's own firm to carry out litigation on P's behalf, that is a decision that is being made for P, and therefore is a decision that always has to be taken in P's best interests. And so if a deputy was simply instructing their own firm without considering, is this in P's best interests? What are the alternatives here? Then that was probably a decision that wasn't being correctly made in the first place. Section 4 of the Act, Section 1 of the Act, make it absolutely clear every decision made for P has to be made in best interests. Section 4 sets out what best interests means and what needs to be taken into account when assessing best interests. And certainly that risk of conflict of interest always ought to be in a professional deputy's mind. Their appointment as deputy isn't sort of carte blanche that they can use their firm for everything without internally addressing that question of conflict. So to some extent, the court has simply set out what deputies ought to have been doing in the first place. Now, I agree that the particular acts that the senior judge has put out may look, or has set out, do look in some cases as being quite onerous and potentially disproportionate. For example, the need, or in pretty much all cases, to go and get 3 quotations. Although the judge does, at various points in her judgment, refer to the need for proportionality to be considered, and that in terms of getting the quotations and the steps that need to be taken, regard does have to be had to costs and the importance of the issue to P. So I think that in the future, the public guardian is going to want to see, as you've just said, Ruth, documented decisions. Is going to want to see the deputy to be able to show their working, to explain how they came to the decision that instructing their own firm was the right thing to do and in P's best interests. And if you can properly document that and show that you reached that decision reasonably, then there shouldn't be any difficulty in the future. The difficulties will lie if you don't go through that process of identifying, is it within my existing power? If not, what other steps do I have to do to demonstrate I have thought about the conflict of interest and try to address it? Ruth, you touched on a moment ago the question of getting retrospective authority, particularly ones dealing with urgent matters and injunctions. What did the senior judge say about that?
Well, it's obviously possible to do, and if it's really necessary to make an application in emergency and you can't get your application for authority into the Court of Protection before you make your urgent application, then you can ask for retrospective approval. But the senior judge was pretty lukewarm about that. She made it clear that you're going to want to justify in your application for retrospective approval why you haven't been able to make your application to the Court of Protection, even if you haven't got an answer from the Court of Protection before or at the same time as making that application. And any delay is going to have to be explained. So if you are going to make the application urgently for in civil proceedings, then you're going to want to get on very quickly and make your Court of Protection Authority application, because otherwise you're going to have to explain delay. And although it's really quite difficult to see how that could change the best interest analysis. Clearly, the senior judge was keen that the Court of Protection decide these questions earlier rather than later. One of the particular problems of applying after the fact is that the deputy is going to be at their own risk, that the court will decide that they shouldn't have issued the application if they wait and make an application for retrospective approval. One of the things that is particularly concerning in making an application for retrospective approval is if the deputy is applying for an urgent injunction for P, because obviously that's going to require the deputy as litigation friend to give a cross undertaking in damages for loss suffered to the other side as a result of the injunction put in place. I myself would not want to put myself personally at risk, or my firm at risk, of the costs of paying up on the cross undertaking. So this was canvassed with the senior judge, and she said that an urgent application could be marked in the urgent business list so that the court would make a decision quickly, so that this could be authorised, and so that an indemnity could be put in place that was cast iron for a deputy in those situations. But David, do you think that the court's likely to be able to give that kind of emergency response? There's been a lot of applications, I hear, as a result of ACC from some firms and some professional deputies. There's already quite a lot of backlog in the Court of Protection. Is this realistic?
Well, it's a very good question, Ruth. I don't have a complete answer to that, but anecdotally, I know that the Court of Protection has been quite badly affected by the practical consequences of the COVID-19 pandemic. Virtually all property and affairs cases are dealt with on the basis of paper files within the court. So physical documents that have to be handed to judges, which are precisely what one doesn't want at a time when we're all meant to be socially distancing. And I think a lot of, from a practical point of view, there's had to be files couriered to judges' houses and the like. It has not been a particularly, it's not been easy for the court. The court is now accepting, I know, applications by email in property and affairs cases, and I think from a practical point of view, the increase in applications following ACC and it's the fact that it has coincided so closely with the difficulties of the pandemic has doubtless caused difficulties for the court, and I'm sure there will be delays in dealing with applications. As for the future, I mean, obviously it'll be a question of resources as to how quickly the court can deal with any backlog. I anticipate that in the future, the need for these applications will gradually decrease. One of the points that you've already touched upon was the need for a prospective deputy to identify, when applying for appointment, the possibility that they may wish to instruct their own firm. And as matters progress and more deputyship orders are made where consideration has been given to that point, the need for immediate and urgent applications to the court to deal with specific issues may well go down. Ruth, do you think this is going to be a change in the landscape? Or do you think this is going to just increase costs for P as deputies undertake a tick box compliance exercise?
Well, I think it's a bit of swings and roundabouts, actually, David. I think that in some situations, what will happen is that there will just be an increased cost for P as a tendering exercise is undertaken at cost to P, and that very little is going to change in P's experience, and that will just have ended up in a costly extra for P. But in other cases, it might be that the need for tendering means that a more suitable firm or a cheaper firm are identified that could lead to cost savings for P that could be substantial. In some ways, you might expect that there wouldn't be a great deal of difference under the new regime from the old one, because as you said, Senior Judge Hilda just explained what deputies should have been doing all along. And I know that there are, for example, deputies that I have worked for that always used to tender for example, conveyancing transactions, because they knew that their firm would be much more expensive than a firm local to the property. So I think that if you were applying best practice before, there's going to be very little difference. I think that it may well mean that because it's very clear now that you shouldn't be charging for acting as litigation friend, that will reduce some cost to P, because I suspect that that in some cases deputies haven't thought about that and have just been charging as they would normally for acting as principal. But on the other hand, they might decide that they don't want to act as litigation friend for P if they can't charge for their professional time. So that might mean that the official solicitor is asked to act much more as litigation friend in civil proceedings, but they instruct external solicitors, so they might instruct the solicitors that were involved in the case anyway, having undertaken their own tendering exercise. I think there's going to be more of an assessment of merits of litigation for P at an early stage, and that could again be more costly because you might have to get counsel's advice, which you might otherwise not have got, to make your sort of court protection better application. But I think in general that's likely to be a good thing, because it might mean that disputes are properly understood from the beginning, and they can be closed down if they're not worth pursuing, which would be a benefit to P. I have heard people say that tendering might just turn into sending your cases to your friends and it will just go around in a merry-go-round. But I think that the deputies I work for tend to be very professional, and I would expect that they would choose firms who they thought were appropriate to act for P in the tendering process. And I think that if that isn't happening, the OPG are likely to sniff that out in their compliance procedures. So I think that there will be some changes and there will be additional bureaucracy that will be costly for P, but there will be benefits to some Ps as well. What do you think, David?
Yes, I generally agree. I think that it's going to, I think anything that keeps the deputies focus on the need to ensure that all decisions are made in P's best interests and any conflict of interest is properly addressed is a good thing. It is going to cost some more money. It's going to certainly deal with, it's going to lead to people having to take steps which are in some cases going to seem overly cumbersome or unnecessary. But what it does do is try to ensure that corners are not cut, and that the process of deciding whether or not a particular step, a step which involves a potential conflict of interest, is genuinely in P's best interests, is properly considered and properly documented. So I can understand where the senior judge was coming from.
One thing that's not really specifically to do with this case, but this case has made me think about, is that I've been involved in a number of property and affairs test cases, and I know you've been involved with many more than I have, David. And I do get concerned that the process of being involved in a test case is actually quite bad for an individual P. I mean, I particularly think about the P in ABC and Watt, who would have been much better off not been involved in a test case at all. the costs can be so high, and the usual rule as to costs is that the costs come out of P's estate. That was to some extent mitigated in this case by the fact the OPG didn't take their costs, and both Irwin Mitchell and the OS limited the amount of costs they were claiming from the P's that were involved in this case. But it's very expensive to for ACC to find out that perhaps some tendering should have taken place.
Indeed, Ruth, and I mean, I've been involved in other cases. For example, the case a couple of years ago on the appointment of solicitor-owned trust corporations, and it's a difficult line to tread. The court clearly sees a huge number of applications. It is in the best place to discern a common thread or a particular point that is cropping up again and again that concerns it, but equally, if you are the unlucky P whose case is chosen by the court to explore that particular issue, there are consequences. It's not very fair on P. It's not particularly fair on the law firms involved, who are often expected to take a haircut and not recover the totality of their costs. I'm afraid I don't think there is a good answer to this. If the court didn't list these as test cases, the issues would still have to be addressed. And at least by listing them as test cases and conjoining 3 or 4, as in the trust corporations case, I forget how many, but it was about 20 or so. By combining those cases, you do at least spread the cost more widely than by dealing with it all in a single issue, as indeed was the case in the ABC and Watt.
So David, we have actually got some interesting questions, and indeed I was very excited to see that someone from Mauritius has joined us. We wouldn't ever be able to easily provide lectures to people that far away, and one of my ways in which I've been passing my time in lockdown has been to try and perfect my dol puri recipe. So very excited that people have decided to join us from far abroad. And we do actually do a fair amount of conflict of laws work within the Court of Protection, and have some expertise in doing work under other jurisdictions' mental capacity law. So that's really great. One of the questions that has been asked by an anonymous person, which I think is particularly relevant for you, David, is would you need authority to enter into a prenup or postnup or cohabitation agreement with P? You did a prenup case last year, didn't you?
I did, Ruth. My own view, I would have said that a prenup or a cohabitation agreement is ancillary to general issues relating to P's property and affairs. Although it is governing what will be the consequences of a breakup of a marriage or of the ending of a cohabitation, that is dealing with the circumstances where the agreement applies. The underlying issue, which the agreement is focused on, is how P's property and affairs will be dealt with in those particular circumstances. So I think a prenup or a cohabitation agreement is very much focused on what will happen to P's property and affairs, and I would have thought it is included within the general authority. Would you agree?
Yes, I think so. I would agree with that. I think that that's exactly the sort of thing that you'd expect a deputy to be able to do, a bit like entering into a lease, although I appreciate that there are particular provisions that deal with that in the standard deputyship agreement. One of the other questions that we've had is, to what extent do the principles apply to an attorney acting under a registered lasting power of attorney where the donor lacks capacity? Well, in particular, I would say that as an attorney, you would still want definitely to get authority to litigate, not least because you'd want the cast iron indemnity for your costs and any adverse costs order that's going to be coming your way. So I would definitely apply them in respect of an LPA or indeed an old EPA. What do you think, David?
I would entirely agree. I mean, I think it's worth bearing in mind that an attorneyship doesn't give you any right under Part 21 of the CPR to act as litigation friend at all. So you have to rely on being solely an individual who can fairly and competently conduct the proceedings and has no adverse interest. And so I think that exactly the same points about conflicts of interest arise with a professional attorney, as would arise with a professional deputy. And so, yeah, I would entirely agree that you should treat the position exactly the same.
Michael, oh,
I was going to ask, read this one out, Ruth.
okay, fine.
So, do you think this comes from Michael Henry? Do you think there's going to be an increase in family members acting as litigation friend?
Do you want me to answer that, David? Sorry.
Yeah.
So I think that there might be a bit of an increase in family members acting as litigation friend, but I think that in general, where family members could act as litigation friend before, they were chosen in priority to a professional litigation friend if they were appropriate. I think that there probably isn't much additional capacity for family members to act as litigation friend in civil proceedings. So I think that there will be more OS acting if professional deputies don't want to be litigation friend because of the fact that they won't be able to charge for their time. That's my view anyway.
So Ruth, another question that we've got: deputies have to have their costs assessed every year and are usually restricted to the historical guideline rates of 217 per hour for a partner. If a deputy instructs their own firm to conduct litigation on their behalf, do you think the litigation team will be restricted to COP rates for the COP litigation or general civil litigation, or do you think they can charge their usual much higher hourly rates? That's from Sarah Foster.
Thanks for that question, Sarah. And actually, it's right, isn't it, that Irwin Mitchell were proposing to charge only court of protection rates for their other teams in the litigation which David and I were involved in. I think there might be a difference between COP litigation and general civil litigation. I think it might be quite difficult to charge higher than COP rates for COP litigation. It might be difficult to justify that, but I don't see why general civil litigation teams ought to be restricted to COP rates. However, I think it's definitely the case that whether on the standard basis or on the indemnity basis, the court is going to insist that the Supreme Court Costs Office assess the costs to make sure that P is protected from disproportionate and too high costs. So there will be, if the rates are higher than might be expected, they will be cut down at that stage, and also there will be a proportionality assessment affected where there's a standard assessment too.
Right. Ruth, we've got two more questions. One I think we've really covered, which is the is this going to increase, is judgment going to increase costs for deputies, well, increase cost risk for deputies who don't follow the guidance set out now? I suppose the answer to that is yes.
Yes, I think so. I think that previously you might have been able to better get away with applying retrospectively for approval, but the clear guidance of the senior judges that you should be applying immediately in advance, and having to justify all the time that you've spent in waiting to make a retrospective one. So I think there will be a more of a cost risk for deputies in that case.
And our final question: is it necessary to get retrospective authority and or future authority for litigation costs in a case where the deputy's firm has already been acting for some time prior to the decision in ACC? I would say the answer to that, that's come from Jane Maitland, and I would say the answer to that is yes. I think that ACC sets out not only future best practice, but really what the Court of Protection thinks deputies already ought to have been doing. Sorry, Ruth.
Oh, yes, no, and I know from speaking to professional deputies that they have been making lots of applications as a result of ACC. I think that's in cases where they've been acting and they want to make sure that their approval is obtained by the court having read ACC.
Right, well, those are all the questions we've had. Thank you very much for your questions. Thank you also for attending today and listening to what we've got to say. We hope it's been useful for you. And thank you very much. Goodbye.
Thanks ever so much, David. Goodbye.